Hello and welcome to Legal Briefs. This is attorney Jeremy Hogan and this is the XRP only edition because there was some juicy stuff filed in the SEC versus Ripple case yesterday, and if you don't know, soon you will know. So, in our ongoing saga, we now know that Ripple had scheduled and subpoenaed former SEC Director William Hinman to be deposed in the case, and the SEC yesterday filed a motion with the court to stop that from happening. Juicy stuff, since Director Hinman publicly stated that Ethereum was not a security back in 2018, all the while apparently receiving money from his old firm, which was heavily involved in, yep, you guessed it, Ethereum. His pension was 7 times his salary. Now, this practice is known as a golden parachute, where you leave a company to join the government and still receive a pension from your former employer. Except Director Hinman went a step further and then rejoined his firm after leaving the SEC, which I will heretofore call a golden on the public. What, you can't say that on YouTube? Listen, I have no problem with private contracts or people moving from the private to the public sector or vice versa. I just think when things become too blatant, we should at least do something like this just to make ourselves feel better.
Shame. 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 Shame.
We will heretofore call it the crony capitalism walk of shame. Except we definitely want them to have their clothes on. I actually wanted to play Shame Shame by the Foo Fighters, but I got copyrighted by YouTube, so I had to go with the Game of Thrones things, sorry. In any case, lots of juicy legal stuff to geek out about today. I'm really excited. The SEC filed its motion to stop the Henman deposition from taking place, and for me there were some super interesting legal issues in there, and I think we can get a good idea of what the judge is likely to do, but also we get a look at some very interesting documents that were attached to the motion as exhibits, and I'm going to point out some things in there, in those documents that you will want to see. I can't wait. Remember, please do not take anything I say as legal advice. I bought a Betamax back in the day, for Pete's sake. Instead, I would recommend you call one of this gentleman's call centers. His main office is here in Orlando, just 10 minutes up the street from mine. Now, who is he? Legal Briefs bonus points if you drop his name in the comments. Okay, so Ripple had subpoenaed Mr. William Hinman to testify at deposition on June 30, only 5 days from now. Deposition testimony is under oath, and it's just like you were in court testifying. The transcript or even the video of the deposition can be submitted to the court and offered as testimony just like you were in court. I've done hundreds of depositions, and I usually show my clients this Lil Wayne deposition to show them how it's done.
Clearly, Lil Wayne answers to no one.
Is that an interview that you actually gave with Katie Couric?
Is that an interview that I actually gave with Katie Couric?
Yeah.
What's your name again?
Hey, well, that's not the question.
What's his name?
Pete Ross.
Huh?
Pete Ross.
Pete Ross.
Yeah.
That's a stupid ass question. You just saw me on there giving an interview with her.
Okay. So that was you.
Objection. That's a stupid ass question. Classic. Okay, so the legal question is, will Mr. Henman be forced to testify or not? Let's take a look and find out. In its motion to stop the deposition, the SEC lays out its argument in the second paragraph, and here it is. Quote, to depose a former high-ranking government official like Director Hinman, defendants bear the burden of showing exceptional circumstances justifying the deposition. Now, this is actually a two-part test. First, the person you want to depose must be a high-ranking official, not just any official. And second, there must be exceptional circumstances. In other words, President Biden is the head of the executive branch, but we can't be having him deposed every time the FDA is sued for not approving a drug. You have to show why you need to specifically depose him. And a quick shout out to SEC Attorney Layden Stewart. This motion letter was actually very well done. Props to you. Everyone else, don't hate me. So that's the arena we will be playing in here, and normally I would wait until we see Ripple's reply brief, but we don't have to because in the exhibits we have a letter from Ripple to the SEC which will essentially become Ripple's reply brief. It's Exhibit D, and it was a letter to the SEC attorney explaining why the deposition should take place. And this is something I've noticed with Ripple's attorneys. They are always a step ahead. I mean, they knew back in January they were going to depose Henman. They knew the SEC would fight it, and this informal letter is already written written like a legal brief. You can almost just cut and paste it as a reply brief. And it starts off where my mind initially went to, which is, if Mr. Hinman no longer works for the SEC does not represent him. Now, what right do they have to object to him being deposed? And that's the first thing Ripple mentions in the first paragraph of its letter. Quote, during our meet and confer on Friday, June 4, 2021, the SEC acknowledged that it does not and cannot represent Mr. Hinman. Close quote. Skip. The law confers standing on the SEC to seek a protective order precluding Mr. Hinman's deposition only upon a showing of good cause. Next, the letter addresses our two-part test. It argues first that Mr. Hinman was not a high-ranking official, but just the head of one of 29 divisions reporting to the chair of the SEC. That's at the top of page 2 of the letter. The letter then, of course, goes on to argue that there are essentially exceptional circumstances here which require his testimony, and that's the second part of the test. And normally at this point, I would take a look at the argument and do my best guess as what the judge would rule. But no, today I have gone a step further because our judge, Judge Netburn, has actually ruled on this issue before, and I have gotten my dirty little hands on those rulings. So let's see how she approaches this issue herself. Now, in this case, it was a lawsuit against Saudi Arabia for the 9/11 tax, and the officials to be deposed were foreign nationals, but the analysis was exactly the same. In her order in this case, Judge Netburn drew a very bright line between current officials and former officials, and was much more lenient in allowing the former officials to be deposed. In fact, she gave former officials their very own section. Under that section, as to the first part of the test, whether they were high-ranking officials, she was very liberal. For example, on page 32, she held that the Saudi Arabian deputy consul in Los Angeles was a high-ranking official. Now, I'm honestly not sure what a deputy consul is that is in Los Angeles, but it doesn't seem very high to me. But he was high to Judge Netburn. In fact, the only individual that Judge Netburn found was not a high-ranking official was Mr. Mazyed Ibrahim Al-Mazyed, who was a cultural attaché. I have no idea what that is either, but in any case, I think Ripple will probably lose on the first prong of the test whether whether Mr. Hinman is a high-ranking official. But Judge Netburn was much easier on the exceptional circumstances part of the test. In fact, I didn't see any analysis involving former officials where she held that the deposition would not be allowed to go forward. And in fact, she allowed all the depositions to go forward in the Saudi Arabia case with this caveat. Quote, plaintiffs may therefore ask questions about false representations made regarding the accreditation of Saudi propagators, as long as those questions do not concern the official's decision-making performed in the exercise of official functions. Close quote. In other words, applying that rationale that she made in that case to the Ripple case, she will rule that Ripple cannot ask about the deliberative process of arriving at the conclusion that Ethereum was not a security. So yes, I think she will allow the deposition to move forward subject to proper objections by the SEC at deposition, but a deposition I think there will be. Which might be a small problem for the SEC because the speech itself, which is the subject of all the hoopla, was all about his deliberative process. So I don't know how you can object to privilege when the whole speech at issue is out there on the internet. And here's Mr. Hinman's deliberative process right on page 3 of Exhibit C in the motion to quash. Quote, and putting aside the fundraising that accompanied the creation of Ether, based on my understanding of the present state of Ether, the Ethereum network and its decentralized structure, current offers and sales of Ether are not securities transaction. Close quote. Now that is straight from his speech. That is public record. And now, thanks to this motion, we have a legal record as well because the SEC went out and got a declaration under oath from Mr. Hinman, an affidavit to support their motion. And as I read the affidavit, I just kept thinking back to when I was teaching ESL and I would use flashcards to teach idioms, and this is the one I kept thinking of. Digging your own grave, for our foreign Englishers, is when you keep trying to do something, but you just make the situation worse and worse with your efforts. Now, take a look at this wondrous paragraph from Mr. Hinman, paragraph 13. Quote, the speech was intended to express my own personal views. During my preparation of the speech, I discussed my thoughts with other Commission employees as part of the Commission's ongoing deliberations about whether offers and sales of Ether constituted securities transactions. To the best of my knowledge, the Commission had not taken at that time, and still has not taken, any position or expressed a view as to whether Offers and sales of Ether constitute offers and sales of securities, close quote. So, it was just his own personal view that he happened to arrive at in collaboration with other people at the SEC, and which the SEC still has not arrived at an official position. Which is all just splendidly confusing and makes you wonder what crypto market participants could have taken away from his speech, and when we as market participants leave the high-ranking SEC officials' big speech scratching our heads, is that fair notice? Well, let's say we figure it out. It's his own personal views. Okay, got it. So we go home and we turn on the television and there's Mr. Hinman being interviewed and we watch this.
In your speech that neither Bitcoin nor Ether would be considered securities and thus not under the purview of the SEC, can you very briefly explain what your reasoning is?
Sure, Bob. These are complex facts and circumstances tests, but when we look at Bitcoin or if we look at Ether and the highly decentralized nature of the networks, we don't see a third-party promoter where applying the disclosure regime would make a lot of sense. So we're comfortable in some sort of viewing these as items that don't have to be regulated as securities.
So, did you notice the pronoun he was using? We. We feel and we think. Remember, nothing gets by me. So, if these are his personal views, who is the we he's talking about? Is he referring to him and his wife in their discussions over dinner about crypto securities laws? Or is he saying that we, the SEC? Or to give him the benefit of the doubt, perhaps the we is just his department that he heads. Fair enough, but the corporate finance department, which he was the head of, is the department of the SEC, which provides no action letters, which makes determinations about what is okay to do and what is not okay to do. And so this affidavit, even if the deposition is not allowed to go forward, is now out there as Exhibit A to the fair notice motion for Ripple. Think of it kind of like Rudolph's cute little nose, bravely leading Santa's sleigh through the harsh, blinding snow. And it's a great lesson in how legal cases are like a game of chess. It's all about having a strategy and thinking further ahead than the other player. Back in early March, look who we can see in Exhibit E to the motion that Ripple listed as a person who would have knowledge about the case. Right there, number 8, there he is, Mr. William Hinman, and Ripple says in this disclosure that he would have notice of the, quote, determination that Bitcoin and Ether were not securities. Now I saw that and I thought, well, Mr. Ripple attorney Gary Gasparov, you probably knew back in January that you would end up in front of Judge Netburn arguing a motion to quash a deposition. Well played indeed. Thank you always for watching. In farewell, allow me to quote from the notorious B.I.G. You know very well who you are. Don't let them hold you down. Reach for the stars.